war crimes and crimes against humanity. So in other words, the Rome Statute is giving us the framework upon which we can work in addressing this gross human rights violation. But there are also other sources. As I said, for the genocide, there is the Convention for War Crimes. We refer to the Geneva Conventions and protocols of international humanitarian law. And crimes against humanity are also covering issues such as rape, as torture, disappearances that are protected by other human rights treaties. And there is also jurisprudence from the different treaty bodies, but also from regional courts, regional human rights systems. In that sense, and historically, we tend to say that transitional justice, whatever the historical perspective might be, somehow is coming from the Latin American context, where during the period that's been called democratizations of Latin American countries, the passage from dictatorship, military rule to democracy has been made in almost all cases based on providing amnesty to those who were in power. And this situation has been addressed and challenged by the human rights movement and by human rights lawyers. In some cases have been brought to the regional Inter-American Human Rights Court, and establishing a jurisprudence that any type of serious crime, gross human rights violations, there is an obligation of the state to investigate, prosecute and punish. There is an idea that impunity is not acceptable from the perspective of human rights in general, but that's the purpose of transitional justice. These international serious crimes cannot be limited. There is this concept of limitation of human rights under certain circumstances. The case of international serious crimes is accepted and is established by law that there is no limitations. And this is reflecting as a non-derogable rights that are protected by the Committee on Civil and Political Rights. There is the right to a remedy, which has been also recognized in many treaties, which is the basis in the context of transitional justice, to clearly establish that reparations is a fundamental element of justice. And in addition to this very, very brief framework of the relevant legal standards and the different crimes, there are two documents that are considered as soft law, but are providing a very clear framework for combating impunity and transitional justice. These are the first one has been adopted by the General Assembly of the United Nations. It's the updated set of principles for the protection and promotion of human rights through action to combat impunity. This is updated principles that were firstly elaborated by the human rights experts called Joannet. So we tend to still use the Joannet principles. These have been updated and they go through the different pillars I've mentioned and making very clear recommendations towards the states in relation to the right to justice, right to know, right to reparations, and non-recurrence or institutional reform. The second one are the basic principles and guidelines on the right to a remedy and reparation for victims of gross violation of international humanitarian law and human rights law, adopted in 2006. The last principle I'm mentioning are really focusing, that's reflecting the victims' perspectives. We tend to focus on what the states, the obligations of the states in terms of addressing serious international crimes. But there is a trend to really make sure that the perspective of the victim to be repaired, to be restored in his rights, are conducted to a series of principles and guidelines. So this is a very, very brief overview of the legal framework, just to say that we have a series of international instruments establishing clearly these different elements against impunity. So these are, again, the four pillars I've already mentioned of transitional justice, which are, as I just said now, they are bases on legal norms, but are also translated into mechanisms, state practices, and facing each of them different challenges. Now, the experts working in the field of transitional justice, and that's the spirit of the different norms, consider that these pillars cannot be separated. They have to work together. They have specificity, but they also need to be complemented by the other pillars and mechanisms. If you just have justice and no reparations programs, no reparations, in the context, again, I should have emphasized that maybe at the beginning, when we're talking about gross human rights violation, when we're talking about genocide, widespread, this is systematic human rights violation, and some of you may have direct experience in terms of that. This is affecting the whole society. So this is not about addressing one case or a case of human rights violation. It has a dimension that is definitely challenging, and the idea of these four pillars that may actually not be enough, and there is a discussion about whether some other mechanisms or the scope of this mechanism should be enhanced, but the idea is that they should be considered and applied together. So the right to justice. The right to justice, I don't think there is a need to expand on that due to your work in the field of human rights. It is the basic idea that no serious crime should remain unpunished, especially human rights violations. But it's also the rationale that justice is a condition to be a peaceful society. As Yves said, this is an old debate, but it's still very there in terms of what the international community considers the importance of justice and also the human rights movement. A condition to be a peaceful society is because if you have justice, there is no impunity. And we could argue that justice has a deterrence effect, might prevent future crimes or human rights violation by those who realize that they might be judged at some point and might be punished. So that's one of the arguments and the rationale. Now the dilemmas in the context of genocide, like in Rwanda, for example, but in other cases as well, is fairness and or efficiency. If you are going to investigate, prosecute and punish those who are responsible for serious crimes, you need to make sure that you're doing it in conformity with international human rights law. This is not about vengeance. This is not about the word in Spanish. Anyway, it will come back. The idea is that you need to ensure, even to the offenders, those who are responsible to the most horrible crimes, you also have to ensure due process and respect to their human rights and provide judicial procedures that is in conformity with international human rights law. Because you might actually make mistakes, you might actually give an opportunity for revenge instead of justice. But when you have a situation of a genocide of the size of Rwanda, how can you ensure fairness because of the numbers and the size of the violation, but also by the fact that after such events, the whole judiciary was somehow not working anymore based on the fact that most of the people were actually judges and lawyers were part of the victims of the genocide. So you didn't have the system immediately after the genocide to really investigate and prosecute offenders in conformity and with minimum standard of due process. selectivity as well, who you're going, you might choose to go only for, and that goes with the impunity gap, as a dilemma, as a challenge. You might just go for the big fish, just for some but not for all. You might focus only on the head of states or the head of armed groups. And I forgot to mention that, coming back to the Rome Statute of the International Criminal Court, that recognizes responsibilities not only of the state but also of non-state actors in terms of international serious crimes. So the impunity gap and selectivity is an issue, and that can be compensated by the others pillars, as I'm going to mention afterwards. Again, the number of cases. You may actually face an incredible number of cases to deal with, complaints, the size of what happened. That can be a challenge for any administration of justice. And how to make the link between the high responsible of the state and specific acts. How do you clarify, in the context of prosecution and investigation, that some ministers or some military officials might be directly involved in some specific acts that would amount as an international serious crimes. There is a technical, a fundamental challenge in order to make that link. There is a case in the Inter-American system, Barrios Altos versus Peru, where the court's been able to link a massacre that's been committed against civilians that were supposedly confused with a member of a guerrilla, and the massacre was committed by an illegal armed group put in place by the state as a special unit, and they committed this massacre. But just by the fact that there have been evidence that Fujimori actually created, was directly involved and was informed of the creation and activity of